Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this afternoon for submission of 3 cases. And we will begin with, excuse me, I'm on my wrong page. That's why I'm confused. We do have 3 cases. The first case is Principal Securities versus Mark Gelbman. That case is hereby submitted without oral argument. Our first oral argument today is going to be League of United Latin American Citizens versus Iowa Secretary of State and others. After this hearing, the bench, we will take a brief recess for just a few minutes. The next attorneys for the next case can go ahead and get ready, and then we will reconvene. So it looks like the attorneys are ready. It's my understanding Mr. Olson will be arguing. You may proceed.
Counsel, Chief Justice Christensen, may it please the court. The English Reaffirmation Act was passed in 2002. The Polk County District Court enjoined the Secretary of State from, quote, using languages other than English in the official voter registration forms of this state, end quote, in 2008. LULAC knew about the act when it was passed. It has known about the injunction since it was rendered. Nevertheless, it waited 13 years before making itself a stranger to the underlying litigation, a plaintiff in this lawsuit to dissolve an injunction that does not apply to it. There are 3 independent reasons, each of which require reversal of the judgment of the district court that LULAC obtained. First, neither the act nor the injunction invaded LULAC's interests, so it lacked standing to bring this lawsuit, and there was no redress that the district court could offer it. Second, as LULAC admits, and as the district court acknowledged, and in fact used to justify its ruling, no facts or law underlying the injunction have changed, so there was no basis for revisiting it. And third, the district court is wrong on the merits. Its vacature of the underlying injunction was improper, and the declaration it issued misstates the law. The court should reverse and render judgment dismissing LULAC's claims, or in the alternative, reverse and render judgment for the state. I'd like to begin first with standing. LULAC does not have it, and that's because it has no injury to itself, and the injury that it claims was not redressed by the relief that it got from the district court. Our brief and our arguments below focused mostly on redressability. We did not address the direct injury as in-depth as we would have had the Alliance for Hippocratic Medicine opinion come out before our briefing deadlines in this case. But the court can see clearly from Alliance for Hippocratic Medicine that a party cannot spend itself into standing. A party has standing if its interests are invaded, as the court pointed out in Allons, I hope I'm pronouncing his name right, when it adopted the Lujan standard. An abstract injury, such as a generalized interest in increasing Latino participation in the political life of the state, is not enough. There must be a particularized, personal injury, something that invades the party's own interests, usually something physical.
Hippocratic Oath, maybe I read it a little bit more narrowly than you did. I mean, we do have a lot of cases, particularly in federal court, that allow for kind of diversion of resources standing as an economic injury to an organization. Do you read that case as overruling kind of that line of precedent or undercutting it in some way that would make those cases not applicable here?
It does not come out so much and state that it is overruling those cases, but the logic of Alliance for Hippocratic Medicine is inescapable. There, the doctors and the association itself claimed that they were injured because they were required to pursue their interest as an organization to spend money explaining what the FDA had done and to spend money lobbying against what the FDA had done. The Supreme Court's holding there was that choosing to pursue your mission, spending money to pursue your mission, is not a particularized injury. It's the same as anyone else who has a problem with the FDA, who's trying to work and lobby against the FDA and get it to reverse what it had done in the past. The same logic applies here. LULAC does not have a particular interest that was invaded. And if you look at the declaration of Joe Henry, the only evidence that they supported, that was submitted in support of their standing, the only interest they claim is not associational standing on behalf of some particular member of LULAC whose rights were invaded, but its own standing, its own injury. And the only injury it claims there is that because of the English Reaffirmation Act, its members have to spend more time explaining forms and explaining processes to people who come to it for help than it otherwise would. That cannot support standing. Say, for instance, that instead of promoting participation in political life, LULAC existed to help underprivileged people with their taxes. If the Iowa legislature...
of that Supreme Court case, but I'm having trouble reconciling that with, I mean, the court knows there's this body of law out there that I think is fairly universally accepted among the circuits, and it doesn't even mention, you know, we're overruling these cases. It doesn't even cite any of those cases or discusses it, and it seems like it's a much more narrow holding about causation, specifically relating to doctors. I mean, at its most narrow reading is how you could interpret that case. So, I mean, would we be breaking new ground to read that case saying all of this line of precedent about economic injury is just overruled without the court explicitly saying so?
I don't think so, Your Honor, for a couple of reasons. First, the court, when it's explaining its holding and standing, it does discuss doctors in particular, saying that it is not going to adopt a special doctor's rule of standing based on the generalized relationships that doctors have with its patients. But it then comes back to discuss the doctors acting through the association that they put together, and states that it is not enough that that association is attempting to pursue the reversal of the decision to approve the mifepristone drug. And I believe it's the exact same situation here. The cases regarding diversion of resources, as the court points out, the boundary of that line of cases, the Havens case that it discusses, there actually was a misrepresentation. There actually was an action by the private defendant in that case that made it harder for the Havens group to do what it normally did, which was to help people apply for Section 9 vouchers. Because of the misrepresentation of the defendant, they had to spend more time actually going forward and getting the correct information so that the vouchers could be properly processed. Here, there's no allegation that there was some wrongful action. The only allegation is that the law exists and it's making life for them harder. That doesn't do it. And
let me ask you this, a procedural question. If there was not a request here to dissolve the injunction from the prior proceeding, I take it the state would have no procedural objection to LULAC filing a DEC action, right? I mean, I know you contest standing, but procedurally, there's no reason they couldn't do that since they weren't a party to the prior litigation, right?
there's no reason that LULAC could not file a DEC action. LULAC could not file this DEC action. And that's because there's not actually an underlying dispute about something that LULAC wants to do. If you look, LULAC's request to the Secretary of State in the administrative proceeding was, one, may other counties use the forms that Buena Vista County developed when it was a covered county under the Voting Rights Act, and two, must county auditors accept the Spanish language version of the National Voter Registration Form. But there's no evidence that anybody tried to use these forms. There's no evidence that someone submitted one of those forms or
I think it's Auditor Miller's affidavit that says that he would do it if he could.
that shows that there's a problem with Auditor Miller. that they should pursue. That goes both to the redressability and to the lack of a basis for the challenge to this. Telling the Secretary of State that the Secretary of State may issue forms in Spanish actually doesn't cause anyone else to do anything. The person that LULAC has a problem with is Auditor Miller, refusing to issue the forms. The underlying injunction does one thing and one thing only. It prohibits the Secretary of State from promulgating voter registration forms in a language other than English. If Auditor Miller wants to put out forms in Spanish, there's nothing in the injunction that prohibits him from doing that. If LULAC wants Auditor Miller to issue those forms in Spanish, it should have sued Auditor Miller and said, your interpretation of this law is wrong. As a matter of fact, the required or necessary exception applies, and you are allowed to have these forms in Spanish for our members and anyone else in the public to pick up. It chose not to do that. It chose instead to raise an argument that had not been raised before, but was available to be raised in 2008 by anyone who had been a party to that litigation. It chose, that is, to go back and relitigate a case that had been closed for 13 years. They argue that
Before you run out of time. I mean, you can finish what you're talking about. I just want to make sure that you get to the merits before your time runs out.
to the merits, Your Honor. The reason that the district court is wrong on the merits is because in the context of the act, there is no other interpretation of the required or necessary language except that it has to be speaking about the use of a non-English language. Otherwise, just as was the case in the underlying proceeding, the exception swallows the rule. If county auditors are allowed to simply decide that something is necessary in a general sense, they now have the discretion to put out any publication and any form that they like in any language that they believe might be helpful.
Necessary or required to secure a constitutional right. Can you tell me an example of a constitutional right that would fit within this exception? Or the type of publication or government action that would fit within this exception?
I think it has to be judged on an individual basis, which is another issue, another reason that this relief doesn't actually achieve anything for LULAC. LULAC is not an individual that votes. LULAC is not an individual that uses these voter registration forms. If something is necessary to vindicate a constitutional right, that means that someone needs it. That means that a person needs it and otherwise can't vindicate the right.
The people that needs it? I mean, I don't read sub H that narrowly.
It could proceed as a class action, Your Honor, if we actually had a plaintiff. We don't have a plaintiff. We have an organization that says that it would like to have these forms available for people as part of its generalized mission to increase Latino participation in the political process. But no, the state believes that it is in fact the case that voter registration forms in another language could be necessary to someone's vindication of that right if that form were the only way that the person could in fact vindicate the right. But there are other ways to do that. The people in the auditor's office could, speaking the person's native language, walk them through the form. They could call the translation line that's available for courts for less frequently used languages to have that person walk someone through the form. It doesn't mean that the auditors have the discretion to decide that something is necessary without an actual particularized showing from somebody who needs it. And that's the...
So you're saying this is not a legal issue, it's an individualized showing that someone has to make, that the auditor was not able to get a translator, and so that was, it goes to that level of need and necessity?
Yes, Your Honor. There actually has to be a showing by a person whose rights are being affected.
Auditor Miller's affidavit, I mean, doesn't he basically say that? I have people come to my office that need help with these? I mean, can't he make that call? Isn't there enough?
Miller's affidavit says that people come to his office asking for the forms in Spanish and that he would provide them if he weren't getting the advice from the Secretary of State that he's getting. It doesn't say anything that the forms are actually necessary.
We're a plaintiff here. You would say that that showing is not in and of itself. If they filed an affidavit and said that they are not English speaking, is not their native language, they don't read English, what kind of facts would they need to show to be able to fit within this exception?
Specific facts they would need to show, Your Honor. I haven't, the state hasn't prepared to defend that case. I will say this would be a very different case if we had a plaintiff who was saying, I can't understand this form because it's not written in my native language, and I need this form in my native language so I can properly exercise my right to vote. And not just the right to vote. Recall, this applies to any language, any non-English language that is necessary to secure a constitutional right. This applies to applications to purchase a firearm. This applies to, a permit to acquire a firearm, as we're supposed to call them now. This applies to people who are applying for property tax exemptions for their church. This applies to people who are having to pay sales tax on their foreign language periodicals. This is not just limited to the voting context. I see that I've run out of time. I'll reserve the remainder. Thank you, Your Honor.
Thank you, Chief Justice, and may it please the court. Uzoma Nkwonta on behalf of LULAC of Iowa. In 2008, the Polk County District Court entered an injunction that prohibited the use of Spanish language voter registration forms in Iowa. The court entered that injunction based on incomplete information and arguments that were never raised at all about the scope of Iowa's English Language Reaffirmation Act, or what we call the English-only law. But when presented with appropriate factual context and directed to the governing provisions of the law, namely the plain text of the law that actually exempts the use of any language to secure constitutional rights, the court recognized that the plain language of the English-only law permits the use of translated voter registration forms and other voting materials. That was a change in the law, and as a result, the court authorized and indeed was required to dissolve its previous injunction in order to avoid inequitable results.
Procedural issue. You'd have to admit is an unusual posture for a non-party to seek to dissolve an injunction in a prior proceeding, right?
It is an unusual posture, Justice McDowell.
Iowa case law that would support that kind of procedural maneuver versus filing a deck action, getting a change in the law, and then allowing the parties who were enjoined to seek relief from the district court if they wanted to do that.
So the best authorities I would point to first is Iowa Rule of Civil Procedure 1.1510, which is a venue provision that establishes venue for precisely this type of action. So it contemplates a separate action, number one. Number two, there are federal cases that have actually recognized and accepted this type of action. We point to a couple of them in our brief, including Wilson v. Minor from the 11th Circuit, where voters separately filed an action to challenge an injunction that had been entered by the court previously. And lastly, I'll point to our own lawsuit, where the procedure that Justice McDonald just described, filing the deck action, is what we did. In other words, LULAC filed a deck action and obtained that declaration. So what the Secretary and appellants are complaining of here is really the fact that the declaration or the deck action did not come in a separate lawsuit or separate proceeding from the action to dissolve the injunction. And there's no law or no authority that requires those proceedings to be separated. Before I delve too much into the procedures, I would like to address something that appellants have raised for the first time in this argument, which is standing both to challenge the King injunction and to the declaratory action, and the arguments based on the Alliance for Hippocratic Medicine. So first of all, the Alliance for Hippocratic Medicine, or FDA case, does not impact LULAC's standing in this case. That decision specifically states that in instances where the court, the challenged action or the challenged law impacts the organization's activities, standing is an easy question. Standing should be easily granted when there's a specific impact on the organization's activities. There is an undisputed record that is set forth in D98 in the record that illuminates exactly how LULAC's activities are directly impacted by the English-only law. Just to give you an example, LULAC of Iowa translates voting materials. They are forced to translate voting materials for their members and their constituents because the English-only law prevents county auditors from translating these materials. And LULAC of Iowa has attempted to obtain translated voting materials for its constituents, but it cannot obtain these materials because of the English-only law and the Secretary's guidance. So LULAC must respond to questions from its constituents and its members, translate notices, for instance, like the notices of precinct changes in Muscatine, and that requires LULAC of Iowa to divert resources from other activities to engage its members in the political process. So you have several different factors there.
Than the record in Alliance for Hippocratic Medicine.
Very different because the doctors in Alliance for Hippocratic Medicine never actually explained how the regulation they were challenging impacted their activities. And that was what the court was concerned about. And you're correct, Justice McDonald, in that it's more of a causation issue than it is an injury issue. There was no causation there because whether mifepristone was approved or not did not impact the doctor's activities. But the approval and the availability of Spanish language voting materials directly impacts LULAC's activities. It directly impacts LULAC's ability to assist its members to engage in the political process, and it impacts LULAC's ability to help translate materials for its constituents.
My question is then ultimately, when we look at this concept of necessity, your friends on the other side talked about other opportunities that people who don't speak English have to obtain translations. At what point does it become necessity to grant this relief you're seeking? At what point is necessity versus sort of just helpful to the mission of your organization?
So that argument about what's necessary to secure the right to vote that you heard from appellants is completely untethered from the actual statutory language. The language in the plain text of the English-only law, section 1.185, says, exempts any language usage required by or necessary to secure the rights guaranteed by the Constitution and laws of the United States of America. So how do we know that translated materials in a voter's native language is necessary to secure the right to vote? Well, we know from several different sources. We know, one, from the congressional record. When Congress passed Section 203 of the Voting Rights Act, that provision establishes a threshold for requiring certain jurisdictions to actually provide translated voting materials. And Buena Vista County here in Iowa was actually subject to Section 203 for several years, I believe. Now, in adopting that provision, Congress recognized that translated voting materials were necessary to secure the right to vote. That was a finding that Congress made. Congress did not require all jurisdictions to provide those materials because you have to balance election administration. But it's already established that it's necessary to secure the right to vote.
After the 2020 census?
After the 2020 census, Buena Vista County is no longer required by law to provide those materials. But that does not make it unnecessary. All that means is that Buena Vista County, that the population, the Latinos or Hispanic-speaking population fell below the threshold that Congress determined was necessary or was required to trigger its protections. But whether a county has a small handful of Latino, native Hispanic speakers, native Spanish speakers, or a majority of native Spanish speakers, that does not make the need for translated materials any less necessary. All that does is that changes Congress's calculus as to when to make those materials required. And notably, the exception that we point to applies to any language usage required by or necessary. So even if it's not required, if it's necessary, it still falls under the exception. And another thing I want to point out is that as you look at that statutory language, you'll see how appellant has attempted to smuggle additional text into the statute. And that additional text that they've tried to inject in there is any non-English language usage necessary to secure the rights. That's not what the exception says.
State's position that reading this subsection H exception that way is kind of the exception that swallows the rule. How do you answer that?
The state has mentioned that, but has not given a single example of how that exception would swallow the rule. Nor is it clear why that would be the case. In fact, I think the opposite is true. I think this is a very narrow exception, and here's why. When you look at the exception, it refers to usage necessary to secure the rights guaranteed by the Constitution, right? When you think about the constitutional rights are, the overwhelming majority of constitutional rights are restrictions on government. They're restrictions on government action. And the small minority of them are actually affirmative rights. And that's why the right to vote is actually different. The right to vote is so unique because it requires government action. It's a right that...
What about the right to due process? How would that shake out under your interpretation of this exemption? Let's say criminal case, for example, right? Do trial informations have to be filed in different languages?
In this case, if there is some trial information that was necessary to provide due process to the criminal defendant, that would fall under this exception. That doesn't mean, Justice McDonald, that it would have to be provided, because again, this exception is not about forcing anyone to do anything. This exception is about exempting a specific usage from the prohibition. So all the exception would do in your example is it would not prohibit the court or the prosecutor from providing the defendant that information that they need for their due process rights. And that makes sense. So due process is one example you gave. The right to vote is another example of where the government actually needs to do something to provide for that right. But in most of the scenarios, you're really talking about restrictions. So it's not, there isn't a...
I'm not sure that I disagree with what you just said, but it seems to me that that does swallow the rule, right? That essentially your argument is, despite this law, when any government official decides that use of a foreign language would be useful in the government context, then they can do it. I mean, due process applies to almost everything under our current jurisprudence. So why can't any government interaction at the discretion of the government official involved just proceed in a different language?
Donna, I would answer that by first, and not to get too far down this rabbit hole of due process, but I think it is more limited, right? It's more limited to government deprivations of rights and liberties. And when you limit it, I think you really have a case-by-case scenario there where you have to determine whether a certain action is actually something that could result in a deprivation of rights and liberties. Voting rights is a different context, right? When you're in an election, you can tell there's a finite set of materials that you need to use to vote. And for that reason, when you get beyond these examples we've talked about, it's very difficult to identify any more of them. And when you look at the other exceptions, it's also consistent with the other exceptions that you see in the English-only law. You see exemptions for travel. You see travel. You see exemptions for documents or actions necessary to complete the census. You see categorical exemptions. And when you look at those types of categorical exemptions, the exemption for something necessary to secure constitutional rights is just no more amorphous than any of the others that have been listed there. Now, I'd like to turn to the arguments that opposing counsel has made about standing. I want to turn back to those arguments as well, because there are a number of issues that opposing counsel appears to have sort of misstated in the law. So, for instance, opposing counsel suggests that Lynn County, the Lynn County auditor's statements that he would provide Spanish language materials, if not for the English only law, is sort of the only basis for standing. It is not. The Lynn County auditor is one of many county auditors, or one of several county auditors that have made similar statements. So the Buena Vista County auditor, for instance, is a respondent in this case, and said they would have continued providing Spanish language materials if not for the King injunction. And they have also clarified that the Secretary of State informed them that they could no longer provide Spanish language materials because of the King injunction. That was guidance from the Secretary of State. And the Secretary of State has authority to provide binding guidance if it wants to. And that guidance is preventing Buena Vista County from providing Spanish language materials. And Polk and Muscatine counties have refused to work with LULAC. So we have multiple county auditors, and all of whom are respondents in this case, which are sufficient to establish standing. I see that my time has expired. Unless anyone has any further questions, I will conclude my argument. Thank you.
Thank you, Madam Chief Justice. There has been no change in the underlying facts or the law. We just heard LULAC again acknowledge it.
So on that point, there was an argument that wasn't made in King. What are we to do, like the district court did, getting this argument for the first time, recognizing that it hadn't been made previously? Are we supposed to say, well, it wasn't made then, even though we may think that it's right, as the district court did? Are we supposed to say, too bad?
Yes, Your Honor, that is what the court is supposed to do. Judgments bind parties, and the parties that are bound to that argument or the lack of that argument are the 4 auditors in this case and the Secretary of State.
And I'm not at all saying that this happened, but that the secretary says, I would really prefer not to have to, produce these documents in different languages. I'm not going to make some argument that I think might win because I'm really not that interested in winning this. What do we do about that?
I looked in Iowa to see if Iowa has adopted the federal standard that there is no standing for collusive suits. I wasn't able to find it, but I think that it would be well within Iowa jurisprudence to state that there is no jurisdiction to hear a collusive suit. So if that had been the case, and in 2008, to be clear in the underlying facts here, I find it unlikely that the Republican plaintiffs and the Democrat Secretary of State and the Democrat Attorney General were probably colluding to reach this result.
That happened. I'm just saying it's curious to me that argument under subsection H was not made, and the district court certainly found merit in it, and the district court in King expressly said that it wasn't reaching that issue. And so this is the first time that any court has really had to address it.
This is why, Your Honor, it's important to remember that judgments bind parties. Whatever the litigation strategy was there does not bind LULAC going forward. And we also just heard LULAC say that their problem is that county auditors aren't working with them. Their problem is that county auditors aren't producing these forms because county auditors are relying on the Secretary of State. If LULAC thinks that the county auditors have the law wrong, they can sue the county auditors, The county auditors can defend by saying, no, this is the interpretation of the law that we're bound by, and there can be a ruling from a court as to whether or not that's accurate or not. And then we actually would have changed law and changed circumstances, as opposed to a direct attack, a direct relitigation of a 13-year-old injunction. Courts don't do that. And that's because there's a value to finality, there's value to certainty, there's value to predictability. Courts at equity did not simply willy-nilly reconsider injunctions.
True only with respect to the injunction that was issued? I mean, I know you have responses as to why the declaratory judgment action shouldn't proceed, but, I mean, that's a totally different vehicle, right?
Different vehicle. And on the declaratory judgment action, there the issue is more with the standing than it is with the attack on the underlying injunction. If there were an underlying dispute as to this that LULAC could raise, a declaratory judgment action would be available. For the reasons I explained before in argument, for the reasons that are laid out in their brief, there's not. But as, you know, in Planned Parenthood 2023, we had 3 justices of the court point out that it was unprecedented to attempt to vacate an injunction without a change in the underlying law or facts. And we had 3 judges who didn't contest that, but the disagreement was over whether or not that change had actually occurred with regards to Iowa law, not whether or not that was the correct test. And that has been the case going back to the courts of the exchequer.
Would be that in this case, LULAC was never a party to that first go-around, correct?
Distinction in this case, Your Honor. And that's why, again, it's important to point out that judgments bind parties. There is not an eternal relitigation exception for injunctions. Injunctions are permanent going forward until the facts or circumstances change, or...
You talked about, we recognized that was an important reason that we could reach it, but I don't think we've ever said that that a change in law or practice was actually required. And you mentioned the word jurisdiction. Are you suggesting that this is a jurisdictional bar? Us being able to hear this case?
I don't believe it's a jurisdictional bar, except to the extent that a stranger to the litigation, a stranger to the injunction actually doesn't have standing to challenge it. If it were the case where there are instances, and the cases that are cited in LULAC's brief actually concern cases where third parties are directly affected by an injunction that was rendered. And there, I believe that party would have jurisdiction to come in and challenge the injunction. But again, it has always been the case that revisiting an injunction requires a change in the underlying facts or circumstances, or at equity, if you're bringing a bill of review procedure, showing that there was fraud, misconduct, or a mistake. In that case, not a mistake, meaning this is something we could have brought up but didn't, but a literal mistake, as in the injunction names the wrong party or it identifies the wrong parcel of property that's subject to it.
Relies on federal precedents that allow non-parties to appeal from a judgment or file an independent action to challenge a previous judgment to which they were not a party. I think it's Wisdom versus Minor. Maybe there's a U.S. Supreme Court case, Martin versus Wilkes. We don't have a lot of case law in that area, but conceptually, what's wrong with the rationale that the federal courts have used to allow this kind of collateral attack?
Actually, I don't think there's anything wrong with it, Your Honor. The problem in this case is that LULAC's interests aren't directly invaded by this injunction. If there are no further questions for the court, we would pray for reversal and rendition of judgment. Thank you.
Of League of United Latin American Citizens versus Iowa Secretary of State Paul Pate and others is hereby submitted. We're going to leave the bench for just a couple minutes before we have our next case, which is MIMG versus Miller and Williams.